Hi, my name is Ashley Mosley, and today I'll be talking about chapters 13 and 14, which deal with copyright and intellectual property. Copyright is defined as the rights given to an owner of a work. Those rights include licensing, publishing, communicating, reproducing, adapting, or translating. Copyrights are given to creators of literary, dramatic, musical, artistic, and sound recording works. Copyrights or laws are given to persons who want legal protection for their creative works or their intellectual property. Intellectual property is defined as creations of the mind, such as inventions, literary or artistic works, symbols, names, and images. A trademark is a word, phrase, or design that identifies and distinguishes the source of the goods or one of the party from those of others, i.e. like brand names and stuff like that. Service marks are symbols that identify a service. So basically people use trademark and service marks interchangeably. Example of trademarks are like Burger King, Kleenex, McDonald's, stuff like that. The 6 basic rights of copyright holders are: 1, they have the right to reproduce their own work. They have the right to. The second one is they have the right to distribute their own work. The third one is that they have the right to derive their own work from something else. So, say for instance, they wrote a book, they want to make a movie off the book, they have the right to do that. The fourth one is public performance. They can perform their work, movie, theater, play, whatever, in front of anybody they want to. The fifth one is public display, and the sixth one is public digital performance of sound recording, and that just has to do with paying royalties. Now I'm going to talk about sampling. Sampling involves one musician taking a recognizable portion of a copyrighted song and using it as a new recording. An example for that would be Vanilla Ice's song Ice Ice Baby. He used the song Under Pressure by Queen and David Bowie. Now I'm going to talk about copyright infringement, which is basically the use of copyrighted works without permission. Another musical example is Robin Thicke's song Blurred Lines, which he basically stole Marvin Gaye's song. And he is going to be paying royalties for that. He does have to pay them like $53,000 million for that. Now I'm going to talk about the Bono Act of 1998. It was named after a California congressman, Sonny Bono. And he made it sure that all copyrighted works are good for like your lifetime. So if I copyright something, it's going to be good until basically I die, and then 70 years after that. Fair use is using copyrighted work without permission. It's basically any work that you can use that you don't need permission to use it. So that could be for if you're going to teach, if you're going to use research, if you're doing news reporting, if you need to make a comment about it, like criticism, anything like that, or if you're making a parody, and all of that is considered fair use. But it is a fair use test. There are 4 ways that you can find out if something is basically, can you use it without having to get a license for it or get permission for it. The first one is the nature of the work. So basically, is it public domain? If anyone can use it, then anyone can use it. The second one is the purpose. How is the work being used? Like, as long as you're not basically going to reproduce somebody else's work, you can use it. The amount of it used. According to the book, the amount of it used is barely ever fair use, because a lot of people don't know when too much is too much. So, and the effect of the use. So basically, if you do something, is it going to ruin my value? Am I not going to get money for it? If it's going to reduce the cost, that it's going to reduce the amount of exposure that I'm getting from it, then it's not fair use.